Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Anora Wang, and today's episode is called Wanna Be an Antitrust Scholar? Meet the ABA Antitrust Section's International Scholar in Residence. So for people who are in the section, it's a fact that we know it's an amazing place and it has many gems. And one of the gems is the International Scholar in Residence program, which has been in place since 2013. But not many people have heard about it or know about it. But today we have the privilege to actually talk to someone who is currently doing that program and who, as I was told, is very much enjoying the program. So it's truly an opportunity for us to learn about what this program has to offer. My co-host today is Jeny Maier. Hi, Jeny.
Hey, Anora. Nice to see you.
Jeny, would you like to introduce our guest and kick off the conversation?
Absolutely. Our guest today is Natalia Moreno Belloso, a final year PhD researcher at the European University Institute in Florence, Italy. Natalia is currently in DC to carry out part of her doctoral research as the 2024 International Scholar in Residence for the ABA Antitrust Law section. The section's Scholar in Residence program provides funding for up to 2 scholars to visit the United States to pursue competition policy-related research. These scholars spend a period of 8 to 12 weeks in the United States, starting around the time of the annual spring meeting, and will conduct research, meet and interact with members of the antitrust community here in the United States, and advance their research through visits to enforcement agencies as well as academic institutions. So welcome to our Curious Amalgam, Natalia. Nice to see you.
Thank you. It's a pleasure to be here. And also, I've been listening to this podcast in the past a lot, so extra special.
Oh, thank you so much. Well,
did you have to mention that when you applied to the program?
Yes, I'm an avid listener of our Curious Amalgam. I think that's what got me in.
Fantastic. Well, first of all, the Scholar in Residence program sounds like a lot of fun for antitrust aficionados like me and Anora and probably most of our listeners here. So could you perhaps walk us through, what's a day in the life of a scholar in residence in the program?
Absolutely. No, it's a lot of fun, and it's an absolute luxury to be able to be here to do research for 2 months on antitrust, what I focus on in my daily life back in Italy as well. And so a day in the life would start with a capital bike share to the Georgetown campus. So while at the ABA, I'm also a visiting scholar at Georgetown Law, so that I have my own office space and everything. So that's kind of my main hub where I work from. And well, not every day is different, but there's definitely a chunk where I do research, which is what I'm here for. And then the other part, what I'm also here for, is to network with people. And this can take form, and this can be an event that I attend to. So I've been scouting all the institutions, so all the academic institutions, all the different universities, if they have some kind of related event, but also the think tanks, the policy organizations and everything. So I try to go to everywhere, so from left to right. So that's a part of it. And then the other part would be meeting with people. So I've been contacting everyone that I want to talk to here. So now that I am in DC and there's such a huge antitrust community here, everyone is here, it seems like I've been trying to arrange meetings to kind of ask them all the US antitrust questions, because I'm coming from an EU competition law background. So it's just great to hear everyone talk about their work.
That sounds wonderful. Let's talk about the networking piece for a little bit. I was told that you have an advisor or a mentor that's assigned to you for being in the program, and you were promised that you can meet anyone that you want to.
So at least he tries his best. So it's Professor Gavel from Howard University. I think he created the program as well. It was kind of his idea to create this forum for foreign scholars to come to the US and for there to be this kind of academic exchange between the two jurisdictions. jurisdictions. And he's been I don't know if that's the correct term, but grandfathering over us. He's been very welcoming, and he said anything you need. So if you any name, the wildest name possible, I'll do my best to try and get you a meeting, to introduce you to people. So he's been amazing. He's really been opening doors. So that's great. It's very valuable to have, I think, in a place like DC.
That's very nice of Professor Gavel. How about the rest of the section? Did you meet other people who are willing to create connections or introduce you to people?
So who's on your wish list?
Yeah. I'm actually leaving in a week, so it's already quite... I think if I haven't managed by now, I maybe should forget about it. But I also have some online meetings planned as well. I'll be meeting Steve Cernak, who's the head of section, I believe. That's what he is this year, no?
Chair-elect.
Yeah, chair-elect, exactly. So I'll be meeting him, very excited for that. And so far I've met mostly academics, so it would be great also to speak to some practitioners. But they're quite hard to get to. They're quite busy, I think. So academics have been a bit easier to reach. So yeah, anyone working on digital, I would love to meet. Then I'm too shy to name big names. But yes, I met Judge Yvonne Gonzalez-Rogers quickly at a reception. So this was already a dream come true. So
that's a privilege.
Yeah. Just to go to some spring meeting, cocktail parties and events, and you will just turn around and you'll knock into somebody with your elbow and start up a conversation. Excellent. So why don't we get started to talk about some of the research that you've been doing. And I understand that your focus is on conflict between competition law values and sort of non-competition law related values like privacy and data security. Sort of, where have you been sort of, seeing that, and sort of, what got you interested in that?
Yeah, so as you mentioned, spot on. I'm looking at conflicts between competition on the one hand and anything that's kind of not quite competition on the other hand. So I call them competition values and non-competition values. And again, as you mentioned, I've been focusing on privacy and security. So I've been really looking at these digital cases where these digital values have been popping up, like privacy or cybersecurity or maybe even online speech. But the broader question, you can broaden that as well. So it can also be non-competition values. For example, in the EU, could be market integration, integrating the different markets within the European Union. It could be labor considerations, the labor protection considerations. It could be really anything that's kind of not the core of competition. But as I said, I've been focusing on digital. And I think what sparked my interest in that, because my PhD started also on digital, but not quite on these trade-offs, on these conflicts. But then the App Store cases really started gaining a lot of attention and a lot of prominence. And you had complaints by firms such as Spotify and Apple complaining that Apple's App Store rules and also Google's Google Play Store rules and policies were anti-competitive for a host of reasons. And Apple started responding to that with not saying sure it is anti-competitive, but they were saying, hey, yeah, maybe there is a restriction, or maybe that's quite a restrictive rule, but it's great for privacy or it's great for security. So it's absolutely necessary that we have this for these reasons. And that's what got me interested in that, kind of how to assess that. Do you accept that argument? How do you assess to what extent that's true? And so on. And then it started in all these antitrust cases against Apple and Google. And then also in Europe, we had the Digital Markets Act that also tackles these App Store rules. And there also the argument was made for security and privacy should be taken into account. So you cannot just completely impose these rules on these platforms. So I've been very interested in that dynamic, how that has been playing out. And then I also saw these conflicts popping up in some other areas. So if you start looking at interoperability or data portability, or really, the thing about these platforms is that they do kind of say it every time they can. They try to make the argument. So you see these dynamics popping up in a lot of areas, and then it's very interesting to see the differences.
Well, coming from an EU academic background, and you're in DC, you have been here for how many weeks now?
2 months. I've been
2 months, and you've been talking to people.
Yeah.
Is there any comparison points that you find particularly useful while you're here, or anything that you have observed on the same issues but in the US?
So it's actually been interesting, because I think we often see the EU system of competition law as compared to the US antitrust system, at least historically, as this more open system that takes more values into account, whereas the US antitrust very much focused on competition and competition only, so it doesn't make exceptions for other values that easily, whereas the EU system is a bit more multifaceted, that takes more goals into account, even though we have then converged into also a system really about competition and economic efficiency and consumer welfare around the 90s. But But then if you look at these privacy and security arguments, in the EU, we haven't really had any judicial or decision saying anything about that yet. We have it a bit in the DMA, but we'll have to see how that plays out. That's also regulation, so it's not competition law proper. But then in the US, we actually have the Epic Games decision where a judge has said, no, that's a valid justification, and it doesn't engage with it. It doesn't really weigh it against the anti-competitive effect, but there's at least a judge has said, no, that is a valid justification. So it's more advanced in a way in the US, even though in the EU we maybe think of the EU as having done these cases earlier, these digital cases, and also being more open to different values. So that's been an interesting comparison to see. Yeah.
Well, you wrote a paper very recently on the DMA called the EU Digital Markets Act Competition Hand in a Regulatory Glove that kind of examines the law and asks, is this a special kind of competition law or is this something different? Where did you land? Where did you come out?
I think we have quite of a cop-out answer. I think we say it's ambiguous. But then we say that's actually the problem, the ambiguity. So the Digital Markets Act, formally, it's very clear. It says, the text, if you look at it, it says we are not competition law. This is a different beast entirely. This is regulation. It's not competition law. For a host of reasons, they go down that path. So the text is very clear. But then in some very important aspects, if you look at the DMA, it's very much just like competition law. So in substance, these are competition law rules. They also stem from previous investigations, from previous cases in competition law, and they've been kind of crystallized in these rules. So the substance is very much of competition law, and there are some other aspects as well that very much make it a competition law instrument. So I think we then say that the DMA talks the talk, that it is regulation, but it might not walk the walk. So if you look at it closely, maybe it's something different. So ultimately, we say it's ambiguous. And then we also outline some areas where that would matter that it's ambiguous, because you could also say, well, in the end, what does it matter if it's regulation or not? But I think I know that we say that it could matter for double jeopardy. So if a firm has been subjected to DMA rules and then is also subject to a competition law decision for the exact same conduct, exact same set of facts, that could be problematic. And also for expanding the DMA, for adding new obligations. If it's not competition law, you might be able to add in rules that have nothing to do with protecting competition, because it's not a competition law instrument. But if it is, it's somehow limited a bit as to what you can impose or what you can add to it. Also for interpreting the rules, once we'll see it being litigated inevitably, do you use what you know from competition law? Can you kind of import interpretative principles from there? So that's how we approach the question of whether it's competition law or not.
Well, that's fascinating. I think your research sounds like you're very interested in exploring, when values or when different principles come into conflict. Is that a fair generalization of your interest? Are there particular trends that you have observed, seeing those conflicts being in place? How are they resolved, either here or in the EU, and how are they different, perhaps?
So the trend so far is that they're kind of now really popping up everywhere. So every time, because also we are seeing more antitrust enforcement against these digital platforms, so more and more they're claiming these arguments. And I think also since the Epic Games decision that I mentioned before, since they've kind of Apple was largely successful in that case because of these privacy and cybersecurity arguments that they were making, well, also because the rest of the case also wasn't very strong from Epic, according to the judge. But since there was some recognition that this could be a valid argument, you see them making that argument. Now they're doubling down on it a lot. So in the US, we had the DOJ complaint a few weeks ago against Apple. And there you also see this, that they devote a whole section to kind of already counter-arguing to these privacy and security arguments, because Apple has been claiming this in all areas of its ecosystem. And also with interoperability that we now see in the EU being mandated through the Digital Markets Act for messaging services. I think Meta is also claiming that that's very difficult to do because of cybersecurity and because of privacy, and how to guarantee that while being open. So it's starting to become kind of a problem. But how regulators and how judges and competition authorities will actually deal with that, how in detail will they look, how much technical expertise will they kind of acquire to be able to because these are very technical conflicts. So how much technical expertise will they acquire to be able to say something about that? How much technical expertise can we expect them to acquire, since they're non-technical experts? So this will be interesting to see, I think, in the years to come.
Are there any other cases? So you've mentioned the App Store cases and the DOJ's case against Apple, but thinking about the DMA in particular, are there any other sort of cases that perhaps are either bubbling up or that you're keeping an eye on?
So yeah, in the App Store case, it's been very prominent, and I keep mentioning it. But to kind of get off Apple's back for a bit, you see it also a lot in interoperability. So there, Meta will have to step up and provide interoperability for a lot of its services, and they're claiming it. So there we see the conflict popping up for data portability. So if you want to port your data from one service to another service, that can come with some privacy considerations. For example, if you port not only your data, your Facebook data, because on Facebook it's not just you on Facebook, and you've been interacting with a lot of other users. So if you port that data, that can come then with privacy considerations that affect your friends and your network on Facebook. So how to ensure that data portability is meaningful? Because if you only really port what only you were kind of engaging with, that doesn't get you very far, because kind of the art of the social network is that it's social, that it's with other people. So how to make that meaningful while safeguarding privacy in a way. So we'll see it pop up there as well as these mandated rules start coming into reality.
Yeah, but here in DC, I guess you also have the advantage that, like, if you want, you can go to a DC, maybe not DC Circuit Court, maybe wherever there is some ongoing litigation on these issues. So hopefully you get some valuable observations from those experiences. Your work has taken you to many universities and academic institutions around the world. But who has been a mentor and perhaps really important to your current or prospective research?
So I'd have to say my PhD supervisor, of course, because he'll be listening, so I have to be in his good graces. No, but I'll just say this on and off mic. He's been amazing. So Nicolas Petit, Professor Nicolas Petit at the European University Institute, amazing competition law scholar. And from day one, so I've now been his supervisee for 4 years. And from day one, he's been he's kind of balanced the academic guidance and focused on your thesis. Famous quote of his is, your thesis is your first, second, and third priority. But he'll say that, and then he'll also encourage you to do a lot of extra stuff that's great for a PhD student to have, one also with forward looking to when you go into the job market. So for example, the ABA program, he really helped me a lot to apply, and he was very supportive. So that was great. With other things, so we co-authored the paper that you mentioned before about the DMA, which was a great experience, and he'd handled that very well as both supervisor and co-author, which is not always easy to do. So he's been amazing. He's been opening doors, and he's been also providing great substantive advice. So
not to give another plug of the program, but I like their information we want to share with our listeners. So how did it come? How did it come to when you were applying? Like, what was the process, and how long did it take? And then I don't know how formal it is.
No,
Do you have to be interviewed?
Yeah, because it is a bit of a. So I think a good advice for anyone that might be listening and wants to apply in the future: contact some of the previous scholars. So you'll see my name now on the list. You can always contact me if anyone's interested in applying, because that's what I did. So I contacted Magali Eben, who was a scholar. She's now working at the University of Glasgow in the UK, and she was a scholar a few years ago. She was actually the last one that came before COVID hit, when the program paused for a while. And she really kind of helped me through that process, because there's no interview, so it's only a research proposal it's a research proposal that you have to submit. But that does mean that research proposal has to be very strong. That was the advice that she gave me, because you won't be able to kind of clarify that in an interview. They won't give you the benefit of the doubt if something's unclear. So the research proposal has to be very strong, and you have to show that why you have to go to DC, or why it's a good idea that they fly you all the way over to come to DC to do research. So that's what I try to highlight. So because my research is on EU competition law, but why would it have been great for me to come to DC? Well, because these issues are they're popping up on both sides of the Atlantic, right? The same maps or rules, as I mentioned, they're being targeted on both sides. So then it would have been great for me to hear how the US is approaching these issues. So I learned about the program, I think the call opened maybe in July. So it was in the summer, in June. And I heard about it maybe end of July. And so I saw it on social media. I don't know if that's a good place to get your news, but it worked for me.
But it's an annual program, right?
It's an annual program, yeah. But it had been paused for a few years. So I think this year, a lot of people, it wasn't on people's radar. So I think in the next few years, it will be more on people's radar. Right. And it's for non-US scholars. So I think that's really the only criterion, that you're not supposed to be American. So that might be your target audience is probably quite American. So it's for international scholars. So you have to be non-American to come to DC and do research on U.S.
And you can stay for 2 months?
2 to 3 months. And the funding is great. So there's no worry about being able to fund this. So that's absolutely amazing. It's a very generous scholarship. And I think the deadline closes end of the summer. So in my case, it was end of August. I don't know if that will change in future years, but it seems to be that's always where the recruitment happens. And then I got the news in October, and then the ABA also provides wonderful assistance to come. So with kind of advising you to also apply to Georgetown, their visiting scholars program, with the visa application and everything. So they've been amazing. Yeah,
that's perfect.
Awesome. Well, as a frequent listener of the podcast, you know that after we wrap up talking about the substance of the conversation, we like to get to know our guests as people. And I wanted to ask you, so you've shared a lot about your experiences with us, but could you tell us something interesting or unique about yourself that we wouldn't know if we only knew you as an academic?
It's a tough question because I'm a notorious oversharer. So if you know me academically, you probably know a lot about my personal life as well. But first thing that comes to mind is I'm obsessed with greyhounds. The dogs, not the bus fleet, not the bus company. I have one as well. He's a rescue, so he used to be a hunting dog. I think a lot of the rescues are also former racing dogs, and he came with me to DC. So I think maybe it's appropriate that I mention him now. So I flew him all the way, and he's huge. He's like a tiny horse, so he'll definitely reach the table here. Yeah, and he's very lazy. He looks very athletic, but he won't move if he's not forced to. And so I love these dogs.
So it's international scholar and their dogs.
And their dogs, yes. Exactly.
Oh, that's perfect.
This may be great to know for future applicants. It's very flexible. You could come with, the whole family.
I don't know about that. But you have already been giving advice for people who are looking to apply to the program. But what about people who want to do what do you do? Doing academic research and you're wrapping up your research soon and whatever your next adventure would be. I guess what advice or what hard lessons or good lessons you have learned in this process?
So I think the world of academia can be quite mysterious if you don't really know what goes on in it. So I remember when I was finishing up my LLM, I had never considered doing a PhD. I thought, no, why me? Even though I was I always did well in my studies, so it was a very obvious next step. But I just had never considered it because I don't come from that background. No one in my family has done it. So my advice would be ask anyone, ask your lecturer, ask your professor, ask anyone you see. If you're interested in going somewhere, look up the current PhD researcher, shoot them an email. If they're not too busy with their deadlines, then they'll probably reply quite quickly, and they'll help you through it. They'll give you advice on, because you're faced with these applications, and they say submit a research proposal. If you've never even seen a research proposal, how do you even approach that? And I think that goes for probably most professions, but academia is definitely one of them. So I would say ask. Even the stupidest question, just ask it. And
yeah.
Well, speaking of questions, we have, as you know, a segment here on our Curious Amalgam called the Curious Hat.
And now it's time for the Curious Hat.
So Anora and I are holding an imaginary hat full of questions, and I would ask you to reach in and pick a number between 1 and 10.
6.
All right. So, question number 6. Anora, would you like to read question number 6?
I do not have the list in front of me, so I'm just going to have to make one up. So, what's a book that you have recently read and you would recommend?
I'm a PhD student, no recreational reading until I finish the thesis. This is terrible because I only read like the worst type. I don't even want to say it out loud. They're just terrible books. They're these rom-com books, and they just take you away.
Guilty pleasure counts.
Yeah, I don't even remember the title. It was in Italian. It was something like Heiress in New York, or it's really bad. I should have just said Or no, 100 Años de Soledad, Gabriel García Márquez. I just never finished it yet. Didn't get through to it.
You're too busy
I
with
know.
research.
Started in the summer and then the academic year started.
Well, that's okay. We can all admit to reading a few bad books in our lives. But Natalia, it's been a pleasure. Thank you so much for sharing your research and sharing your experiences. And we wish you all the best as you finish your program.
Thanks a lot. Thanks for having me.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org Antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.